Yes.
My lord, my ladies, to route my next submissions, I should say where I am. I've just referred to the Royal Opera House case, which addresses what cost component and incorporated into the price means. So I'm almost at the end of dealing with the appeal, as opposed to the respondent's notice point, in addressing where the tribunals went wrong in their interpretation of the direct and immediate link test when applied to a specific exempt supply. The next case I would invite the court to turn to is in the second volume of the authorities, page 489. Up. It should be the Volkswagen Financial Services case. It concerned hire purchase contracts, which, as a matter of law, are treated as two supplies: an exempt supply of finance and a taxable supply of the car. On the particular facts of the case, there was no profit on the cost of the car, but there were profits made on the exempt supply of finance, and those profits were used to pay for overheads, which were used in both taxable and exempt parts of the business. So it was a partial exemption situation. And at paragraph 43, the CJU says this: in this case, it is apparent from the order for reference that the general costs at issue in the main proceedings have a direct and immediate link with the activities of VWFS as a whole, and not merely with some of them. In that regard, the fact that VWFS decided to include those costs not in the price of the taxable transactions, but solely in the price of the exempt transactions, can have no effect whatsoever on such a finding, in fact. I take the court to that as an illustration of a point already made, but here is the CJU itself saying being directly and immediately linked doesn't mean that the source must be the profits from a particular supply. However an input is funded does not determine what it is an input used in.
Isn't it looking at the output saying it doesn't matter if a particular input price or cost is reflected in or allocated commercially to taxable or exempt? That's really nothing to do with it. It doesn't matter where you recover the cost from in terms of your outputs or your sales.
Exactly. And you may recall, my lady, that the First Tier Tribunal in our case, as one of its reasons for rejecting a direct and immediate link with the exempt share sale, found that the costs for the inputs used in that sale came from the proceeds of the share sale. And here is the CJU saying that sort of factor doesn't determine use. Where an input is used doesn't turn on how that input has been paid for. And that must logically be correct. If a business is buying in inputs, whatever they may be, wood for a furniture business, for example, it doesn't matter whether that wood is paid for with the profits of the furniture business, with a bank loan, with an inheritance for a director. That wood is used to make the furniture. Yeah. It is as much an input, regardless of who is paid for it or how it's being paid for.
So you don't, so
not regardless of who is paid for it.
You don't look at how the particular cost is recovered or where it might find itself reflected in the output, because that's just a commercial decision and it depends on what's.
Yes. I'll come back to the directive. Used for the purposes doesn't turn on how the input has been paid for.
And in terms of cost components, what you don't do is say, well, here's a cost, now which price is it reflected in?
Exactly, my lord. And Royal Opera House, which we went to before lunch, included a variety of comments on that. It doesn't mean what the tribunals in this case have understood it to mean. There's been no modification. one more case in relation to the meaning of direct and immediate link. This should be, I think, in the first hard copy bundle of authorities, tab 11. And we'll just pick up at page 62. Page 62, tab 11, it's going to be paragraph 9. This is Mayflower, whose facts are strikingly fairly similar to Royal Opera House. Again, it's a charitable trust which is running a theatre, and it buys in the productions from third parties. It's funding that mainly through exempt ticket sales, but there are also some zero-rated, so taxable supplies of various things, including programmes. And I take the court to paragraph 9 because of the familiar and helpful summary here of the test for a direct and immediate link, which examines cost component and so forth. And the only modification since this paragraph is in relation to the ultimate aim between C and D, where I've taken the court already to the case law on that now having a role to play in relation to overheads. Could I invite the court to read that paragraph? That is the test which should have been applied by the tribunals in this case. It describes direct and immediate link essentially being the same as cost component, talks about the input being essential to a particular output, and it talks about use, inputs used, how particular inputs are used. These words are helpful in relation to Mr. Firth's question about when can we have costs which relate to an exempt share sale but are not inputs thereof because they're not directly mutually linked. It requires, this is between C and D, it requires more than mere commercial links between transactions or a but-for approach. So our example of a number we've given, but the Midland Bank legal services to defend the proceedings that arose out of, related to, were but-for, causatively linked to the taxable services, were not directly and immediately linked to it. Same for any supply where there was an element, minor element, which related to or even was used in an exempt transaction, but where that supply, characterised as a single whole supply, had a principal element which was something else, which was not directly and immediately linked to the share sale. So that is, we say, where the tribunals have gone wrong. In summary, they have correctly applied a test of there's either a direct and immediate link to the specific or the downstream, and that's repeated over and over in SKF and Frank Smart, and the authorities have taken the court too. But they have gone wrong really after that, because they have found that there's some special fundraising test. There isn't. In fact, not all the cases about overheads are fundraising cases. Sveda is not a fundraising case, but the same overheads test is applied in Sveda as in the other overheads cases where fundraising may have been what gave rise to the input being an overhead. What they should have recognised is that the case law has only evolved since BLP in relation to the relevance of ultimate economic purpose, or ultimate purpose, objectively construed for the use of the inputs when it is a question of, is there a direct and immediate link to downstream activity? And when it came to the either-or test that the tribunals applied, in the passages I took the court to this morning, they went seriously wrong in interpreting direct and immediate link in relation to a specific exempt transaction in an overly narrow way, instead of applying the test as described in Mayflower and BLP, more recently in Royal Opera House, where cost component and incorporated into the price don't mean the price must, don't tell us anything about the source of funding, or that the price must be increased to cover the costs, or have specific allocation therein. I would go so far as to say, if that was what the test meant, that would be a breach of fiscal neutrality, because it would mean we could have two exempt supplies that are identical, and they're both using inputs in the same way, but because in one, the contract says, and 20% of this price is going to be used to pay for the inputs, and in the other it didn't, we would get potentially a different outcome when it came to whether the input tax was recoverable. And there we have two exempt supplies using inputs, and all the legislation, all the case law says the same outcome should be achieved there. But the fiscal neutrality problem is at stage 2 if there is no specific supply using the input, in which case we've only got two identical downstream taxable activities equally using inputs, and there shouldn't be a fiscally non-neutral result in relation to whether or not there is recovery of that input tax, regardless of what went on in history, which is not directly and immediately linked to the inputs. That is, in essence, our case. It's worth reiterating that the facts which have not been appealed here include the finding of use of the inputs in the exempt share sale, finding that they were part of the process of selling shares. For reference, we don't need to turn it up to it now because we looked at it before, but that's core bundle, tab 10, page 132 to 3, particularly paragraph 44. There are, we say, odd...
40. Is it 44? Yes, 44, sorry.
40 is relevant as well, but 44 is where those specific findings of fact are made. There are odd and impractical outcomes to this. So pausing on the facts of this case, we have a tribunal that has found that these inputs are overheads, which means that they are used by the general business, no specific supply. And yet, it's also not in dispute that this is a business which carries out its taxable hotel business and also an exempt share sale, subject to the economic activity argument, but assuming that HMRC is right about that, it's actually done two things. One is exempt and one is taxable. So if these costs are general costs, there should be apportionment of recovery. We're in a partial exemption situation. And yet the tribunal has not found that. It's found that their use in the exempt transaction doesn't prevent all the recovery. So that creates a high level of unpredictability for partially exempt traders. There's also no definition of fundraising in legislation. There are examples of it in the cases, but there isn't any tight, obvious definition in the case law. Businesses all the time may use the profits from one type of supply to grow the general business, and that may be perfectly possible objectively to evidence. So does that mean that wherever the profits from one type of supply are being used in the general business, as must happen very commonly, that there is now a need to analyse the ultimate economic purpose as opposed to simply looking at, in the ordinary course of events, which supply is using the input. That, we say, can't be what courts and tribunals should, well, what the courts have found. The need to look at ultimate purpose is only in the overheads cases, where there isn't a specific supply using the input. It can't be that wherever there is fundraising, presumably meaning making money to use in your general business, which is, after all, what the vast majority of supplies for consideration do. Non-monetary consideration is possible, but it's almost certainly not in the great majority of supplies. Supplies are normally for money, and money is funds. So the ramifications of this special regime for fundraising are enormous, and we say must be wrong and not what the courts intended. A few examples. If we have, say, a charity shop, which is selling, or charity cafe, it's making taxable supplies, but its ultimate purpose, subjectively ascertained, is to raise money for its non-economic charitable activities. On this analysis, it would lose its ability to recover the inputs for the cafe business, because the ultimate aim for the funds raised would be use in its non-economic charitable activities. But the cafe next door, which is equally supplying catering, taxable, buying exactly the same bread rolls and the same soups and whatever else it is, as its inputs, can recover its input tax. That can't be the correct analysis. So I have 45 minutes left to address the respondent's notice argument. Mr. Firth's argument, as I understand it, is that because the respondent, Hotel La Tour, and because Hotel La Tour Birmingham, the company whose shares were sold, were in a VAT group, the selling of the shares was not an economic activity. We say it was. We say two things. Primarily, we say it was because the effect of the grouping doesn't mean that the management services, which the respondent Hotel La Tour provided to the subsidiary to manage the hotel business, cease to be supplies, cease to be economic activity. They are just disregarded for the purpose of, essentially, VAT, accounting, charging VAT, and so forth. And secondly, we say that if we're wrong about that, and if we're permitted to make a new argument, even if there are no management services, then the holding of the shares is still more than the mere passive holding of shares. The hotel business in Birmingham is now Hotel La Tour's business, the respondents. It is managing it not through providing services, but simply through managing it itself, and consequently that holding of the shares is also an extension of part of an economic activity. It's not in dispute that if there are management services that are not to be treated as a nullity, then the holding of the shares is an economic activity, because, for example, there are passages in SKF that say that, and that hasn't been in dispute at any time in this case. Very briefly, there is a procedural objection taken to the respondent's notice point by HMRC. Essentially, opposition is the First Tier Tribunal made a perfectly lawful decision on this. I won't, for time purposes, turn it up, but for reference, it's a core bundle, tab 10, page 135, and it's paragraphs 50 to 52, and essentially the First Tier Tribunal applies the ordinary principles, the ordinary cases for late amendment, because the factual background was that this grouping argument played absolutely no role whatsoever in the First Tier Tribunal proceedings until after the hearing, when in written submissions for the first time Hotel La Tour made the argument. So it was considered and rejected as an application for late amendment by the First Tier Tribunal. And our point is that has never been appealed. It's a final binding decision that needs to be appealed. It never has been, and it can't simply be reintroduced in a respondent's notice. It's not the same as, we say, a new point on appeal, because there has been a fully reasoned decision rejecting coming into the proceedings, and that cannot be circumvented now. I note that there are some new cases which Mr. Firth has inserted into the bundle, possibly about this point. If I may, I will respond to those in my reply. I don't see them as especially helpful or relevant, because none of them deal specifically with this situation where there's been a fully reasoned procedural rejection of the late amendment, as opposed to new points simply arising on appeal. So everything that I say after this point, of course, is without prejudice to our primary position that there is a procedural bar, but I anticipate that the court would want to hear in any event.
I think we'd like to hear you on a provisional basis in any event.
Yes, of course.
And we'll deal with the procedural objection in our judgments.
Thank you. So,
can I just be sure I've understood this?
Yes.
This is a pure point of law.
Yes.
It's not suggested it would have changed the evidence or the facts, or that we don't have the material to deal with it.
That is all correct. I would point
So,
out.
So, if they hadn't tried to take the point in the FTT, it would have simply be trying to run a new point on appeal, to which the usual test is, what's the prejudice? And if it's a pure point of law, there's usually no prejudice.
That is true. I would point out that the First Tier Tribunal at 52 did find that there was prejudice because HMRC didn't have the ability to make its oral submissions on the point before the FTT.
Yes, but you've got an opportunity to make oral submissions before us. So you're not relying on prejudice. You're relying on the point that the FTT said no, and that's not been appealed. And that's the ground of distinction between this and the ordinary case.
Yes.
Yes. Okay.
Yes.
No, well, I understand.
The FTT has a wide discretion as to its own procedure. It made a lawful decision. For that decision to take full effect, it has to be treated as a final decision requiring an appeal rather than simply being ignored as though that had never happened in the
Yes, I see.
So that's as far as.
Thank you.
As we
Yes,
go.
thank you.
So if we turn please to the authorities bundle and look first at the legislation, tab 3 please, so first volume, page 6. So this is part of the Value Added Tax Act dealing with grouping, and the key word is disregarded at 1, where under sections 43A to 43D, any persons are treated as members of a group. Any business carried on by a member of the group shall be treated as carried on by the representative member, and any supply of goods or services by a member of the group to another member of the group shall be disregarded. So the effect of grouping is that when it comes to most questions of VAT administration, for instance, the need to charge output tax, the need to include supplies in your accounts and so forth, there is a disregard for supplies between members of a VAT group. We say that means no more than that. It doesn't mean the supplies disappear. It doesn't mean that those intra-group supplies are anything other than economic activity, and consequently the sale of the shares in this case was part of economic activity. The purpose, we do urge a purpose of interpretation of the word disregarded, is not to change what would be a supply, what would be economic activity, into something else. It's an administrative purpose, and that's why it goes no further than to say disregard. It doesn't, for example, de-supply. So the key case on this, binding House of Lords decision on the question of whether or not intergroup supplies disappear altogether or a nullity, they're disregarded, or simply not taken into account for VAT administration is Thorn Materials. Court could please turn to same volume of the Authorities Bundle, tab 10, page 47. finance being turned up. The facts of Thorn Materials, so far as they're relevant, is that there were contracts for the sale of goods, which were entered into between VAT group members, and 90% of the purchase price was paid while they were VAT group members. But before the delivery of the goods and the outstanding 10% is paid, the seller leaves the VAT group. So the question is there tax to pay on all of the price or just 10% of the price? And it is true that this is 1983 Act legislation, but the legislation uses the words any supply of goods or services by a member of the group to another member of the group shall be disregarded. So we say the legislation is identical, and it includes very helpful terminology in relation to the meaning of disregarded. So we're in Lord Nolan's speech, page 732 internally, and right at the bottom, between, well, just above H, that leaves open the question of what is meant by the requirement in section 29.1 that a supply by one member of a group to another must be disregarded. I accept Mr. Pross's submission that it does not mean that the separate existence of the appellants and home is to be denied, or that the sale agreement and the prepayment are treated as not having taken place. What it does mean is the 90% of the supply to which these facts gave rise must be disregarded, or, as Lord Justice Mummery put it, ignored for tax purposes. Page 733, please. Down to about halfway down that paragraph. Does it follow then? Sorry, does it then follow that the supply of goods to the extent of 90% is permanently excluded from charge to VAT? My Lord, I can find no answer in the 1983 Act for any such consequence. I accept Mr. Fleming's submission that Articles 4.4 and Section 229.1 are not designed to confer exemption or relief from VAT. They're designed to simplify and facilitate the collection of tax by treating the representative member as if it were carrying on all the businesses of the other members as well as its own, and dealing on behalf of them all with non-members. So there is the House of Lords describing the purpose of these provisions is to simplify and facilitate the collection of tax by treating the supplies as being all made by the representative member, as if it's carrying on all the businesses that the members are carrying on. Nothing there to suggest what would be economic activity is converted into non-economic activity. Page 741, which is, I haven't written the correct page number down. I'll just get that. Page 56, in the speech of Lord Clyde, who was part of the majority. Talking about the same section with the word disregarded in it. The scope of the section extends to the regulation of the accounting for and paying of tax in the situation of a group. But in my view, it goes no further. I just pause there. Again, there is that purposive interpretation. It has an accounting function, and it requires there to be no need to charge output tax between members. It further recognises that supplies can be made between members and regulates how the tax is to be operated. One member stands in place of each and all of them. For the purposes of the tax in such a group situation, supplies between the members necessarily have to be ignored, but the actual existence of such supplies is recognised, even although the supplies may have no VAT consequences. So there we see again a passage in which the House of Lords is saying the supplies actually take place, there is economic activity, but for the purposes of charging each other output tax and the administration concerned tax, they are disregarded. Similar analysis in Intelligent Managed Services, same volume, tab 13. If we could start, please, page 3. facts were there was a transfer of a banking and support services business from a third party to a company inside the VAT group, and the question of whether that was a transfer of a going concern, because after the transfer, the services are only supplied within the group, not to anyone external. And at 103, if I could ask you to read all of 49 and 50 down to just past E, where the words appear, intragroup transactions it makes are not. So again, on the facts of this case, as in Thorn, there were questions about timing which are not relevant to our case. But what is relevant is what is said about whether the supplies are going on, are treated as economic activity when they're between group members. And we say that, again, here is the Upper Tribunal correctly saying that they do at 50. Although the VAT effects of those supplies are to be disregarded, the activities of the MMSL and the intergroup transactions it makes are not. We say that is the correct analysis. And it's striking, we say, that the only case that Hotel La Tour is able to find to support its argument that disregarded means the intragroup supplies are not economic activity is Northumbria Healthcare, a case that we say, in fact, supports our position. The background to the case is there was an NHS trust which applied for a refund for government departments, statutory refund for government departments, where they bought taxable goods or services that were not used for the purpose of any business. And in this case, it related to cars that were leased as part of a salary sacrifice scheme for staff. And there was legislation concerning that salary sacrifice scheme, which is called a D-supply order, which D-supplies the provision of cars to employees. So if we could look at that legislation first, please. Same bundle, tab 6, page 34. This is legislation with nothing to do with grouping. Value-added tax treatment of transactions order 1992. 2, where an employer gives an employee a choice between, essentially, its wages, salary, or private use of car. The main paragraph underneath the subparagraphs, and the employee chooses the alternative described in B above, then the provision to the employee of the right to use the motor car privately shall be treated as neither a supply of goods nor a supply of services. Now, I'll pause there to draw attention to the very different wording of this legislation. It seems to us this is a powerful indication that where Parliament intends that there should not be a supply at all as a matter of law, it simply legislates in terms that say that. We see it here quite clearly. Shall be treated as neither a supply of goods nor a supply of services. Completely different to a disregard where Parliament clearly doesn't intend to de-supply. And then turning to the Northumbria Healthcare case, same bundle, tab 18. And if we could start at page 214, please. I'd invite the court to read paragraph 39, please. Perhaps 38 and 39. So we see there the court saying very clearly, Parliament wants to desupply, it does so in terms such as these, saying that a particular event will not be a supply of goods or services. There's nothing else in this case of relevance. It's not a case about grouping at all. So that is as far as it goes. But our position is, although it's a case which is only before you because Mr. Firth has relied upon it, Hotel La Tour has relied upon it, it seems to us it actually supports our analysis, which is in accordance with the Binding House of Lords decision that the intragroup supplies are still going on, there is still economic activity. Therefore, the sale of the shares is part of that economic activity and therefore an exempt sale of shares. But we have a second argument. This is the new argument, and I do apply in my application to add it at this stage. We have not yet got permission to argue this point. I understand in relation to what Hotel La Tour says that the timing of it is not objected to, but that beyond that Hotel La Tour doesn't agree, or continues to oppose it.
I think we'll allow you to make the argument, and as before, we'll deal with the question of permission in our judgments.
The only critical point for me to say in relation to the application, I believe, is that there is no dispute of facts. It's a pure point of law. It's simply about analysis of the evidence as to factually what was going on. If Mr. Firth is correct in saying that there's no economic activity in the form of the management services because we treat them as a nullity. So, same bundle please, page 36, tab 7. This is Article 9, from which the concept of economic activity is derived from its predecessors. Page 36, Article 9.
This is the principal VAT directive. Comes from the definition of a taxable person. Bottom left at 1, taxable person should mean any person who independently carries out in any place any economic activity, whatever the purpose or results. Any activity of producers, traders, or persons supplying services, including mining and agricultural activities and activities of the professions, shall be regarded as economic activity. So it's a broad definition. I suppose the other words are relevant too. The exploitation of tangible or intangible property for the purposes of obtaining income therefrom on a continuing basis shall in particular be regarded as an economic activity. So why do we say here that the selling of the shares, and indeed the share holding beforehand, is an economic activity if the management services haven't occurred? Our argument is that if the effective grouping is no management services took place, then Hotel La Tour, the respondent, is performing all the businesses of all the group members, and that includes Hotel La Tour Birmingham's business of running a hotel in Birmingham. So instead of it being economically active through provision of the management services, it's being economically active simply through operating and managing that business itself instead of through the provision of services. That's because section 43(1) says the businesses shall all be treated as carried on by the representative member.
Correct, yes. So, case law which supports that position. Other second volume of the authorities bundle, please, tab 23 at page 294. This is, I think, the CJU jurisprudence, the case of Harness and Helm, and the question there fundamentally was whether shareholding and bondholding were economic activities. And if we could turn please to page 312. If I could, I may just read because they're short. There is thus, paragraph 19, there is thus no reason to treat bondholding differently from shareholding, activity. The answer to the first question must therefore be that Article 4.2 of the 6th Directive is interpreted as meaning that the mere acquisition of ownership in and the holding of bonds, activities which are not subservient to any other business activity, and the receipt of income therefrom are not to be regarded as economic activities conferring on the person concerned the status of a taxable person. So where you simply hold some shares or bonds, we know from paragraph 19 they are to be treated the same for these purposes, that alone is not economic activity, because the only expectation one could have, for instance, of income would be dividends or selling the shares. There isn't a business being carried out, it's simply an investment holding the shares. It's not economic activity. But we say here what we have on Mr. Firth's analysis of the effect of grouping, setting aside the management services, is holding of shares in a manner which is not a passive holding of shares. It is holding of shares subservient to the business activity of operating the very hotel whose business, as a matter of fact, outside of grouping, is Hotel La Tour Birmingham's business. But as a consequence of grouping, Hotel La Tour, the respondent, is managing and operating that itself.
And that's why the sale of the shares is exempt rather than outside the scope.
Correct, my lady, yes. Quite clearly, the ownership of the shares on this scenario is not passive, it's not mere, it is subservient to, it is the mechanism through which Hotel La Tour is operating the Birmingham hotel business. It's part and parcel of it, operating and managing that business itself on this analysis. SKF, we're of course now very familiar with. Same bundle, please, page 425. There is, if anything, an even better description here of when shareholding is economic activity. Down at the bottom, paragraph 31. Moreover, it is clear from the court's case law that transactions relating to shares or holdings in a company are subject to VAT when they are carried out as part of a commercial share dealing activity. No one suggests that's happening here. Or in order to secure a direct or indirect involvement in the management of the companies in which the holding has been acquired, or they constitute the direct, permanent and necessary extension of the taxable activity. So, pausing to look at the last of those two, if there is no supply intra-group management services, Hotel La Tour, the respondent, is itself operating the Birmingham hotel business, it is managing it, and it owns the shares as part of its involvement in that management. And dealing with the final of those three examples, that is clearly a direct, permanent and necessary extension of the taxable activity. And I pause there because, of course, SKF is a case where providing management services for a company in which shares are owned was enough to make that share ownership economic activity. If that taxable economic activity is being performed by the respondent itself, then its ownership of shares in that business must be equally economic activity. We see no reason why it would not be economic activity. There is, if anything, an even more direct connection between the ownership of the shares as the mechanism or part of the infrastructure of operating a hotel business in Birmingham. So, to summarise our position on the VAT grouping arguments, we have a procedural objection, but I've addressed that. We say the word disregard does not mean treat as a nullity. It does not take away the economic activity of the intra-group supplies. Binding case law from the House of Lords, we say, shows that supplies continue to exist. What's disregarded are essentially administrative requirements that outside the group would be there. Parliament had wanted to desupply, it would have legislated to do that, as the Northumbria healthcare case illustrates it clearly is able to do. So there's economic activity because the management services in business of the company whose shares are held and then sold is an economic activity going on within the group. But if we're wrong, then on our secondary argument, the hotel business in Birmingham is Hotel La Tour, the Respondent's business. It's operating that, and its ownership of the shares has a direct, permanent, and necessary extension of the way in which it's choosing to operate that business. It's not a passive investor whose only expectation of any income would be possible dividend and sale of the shares when ownership ceases. On the contrary, its expectation is that it will make money through operating the hotel business, and the ownership of the shares is very much subservient to that economic activity. It's part of the infrastructure of that economic activity. So on either analysis, we say the sale of the shares, therefore, is an exempt supply for consideration in the course of economic activity, and consequently, like all similar exempt supplies, it is capable of being directly and immediately linked to the inputs in question. That brings me to a natural end of my opening the appeal. May I temporarily look behind me just to ensure there isn't a note to pass up? Thank you. In that case, unless there's a question that arises at this point, my lord, my ladies, those are my submissions in opening.
Can you help me, Ms. McCardle, just on, I'm afraid it's back to your appeal point,
Yes.
And I should have asked the question at that point. SKF is quite an old case, 2009, yes. And now, we have got everything there is there? Because if it had been the sort of bombshell that the tribunal thought it was, I mean, the real shift in ground when it came to fundraising transactions, I just have an interest in why there weren't lots of cases that came along in the early teens, but we're not missing anything, are we? We have what there is. There's no sort of tribunal activity. It's quite often in these tax cases you get lots of tribunal stuff, and then every so often it comes up to Court of Appeal. There doesn't seem to be that there.
As far as I'm aware, and those instructing me include policy experts on this area, there's nothing else relevant. There will be other cases that refer to it in one way or another, and it does say some important things about transfer of going concern and economic activity. So it will be referred to
this point.
Places. But on this point, this is the first case that we're aware of where use in an exempt share sale has not been found to prevent recovery of the input tax. And that is one of the reasons why we feel very strongly that we don't want this confusing, and we say a decision with very odd outcomes for partial exemption to stand in the Upper Tribunal. So we're not aware that there is anything relevant, certainly not that has found this analysis that the tribunals have applied is the correct.
Did HMRC issue any guidance in the wake of the 2009 SKF decision, or did it just... I'm
not aware. Again, may I turn my back
or
on
just
my lady?
find out at some,
we will
point.
Out.
If there is anything, I'd quite like to see it, just as a matter of information.
Thank you very much. Yes.
Thank you very much. I intend to broadly follow my skeleton, but dealing precisely with the points my learned friends raised and where I disagree with her. And this all starts from our perspective with the issue. What is the underlying issue that existed before SKF, and we say SKF addressed and dealt with? And that's, I said out of paragraph 12. To understand that, you need to understand the basic approach to input recovery, which I think the parties are broadly in agreement on this, that normally you go through the stages in the way I've described it, stage 1 and stage 2. You ask first, is there a direct link to a specific output? And depending on the answer to that question, you either end there or you go to stage 2. And so I've set out 4 alternative possibilities at stage 1. They're not exhaustive. There are variations, but broadly, you would look and you'd see whether there's a direct link to a taxable output, in which case you get full recovery, whether there's a direct link to an exempt output, in which case no recovery, or if it's outside the scope, you go to stage 2, and if there's no direct link, you go to stage 2. And then at stage 2, you look at the overall activity. That much, I think, is common ground as being the general situation. But then there's an issue. And the issue is that where you have, as a holding company, have a subsidiary, whether the sale of that subsidiary is or is not an economic activity turns upon, essentially, whether you provide management services by way of taxable transactions. And that, again, seems to be common ground, subject to my point, Leonard Friends pointed out, subservient holdings. I'll deal with that later. But in essence, the difference between having an exempt supply when you sell a subsidiary and an outside the scope supply is whether or not, whilst you own the subsidiary, you intended to make or did make taxable supplies to it of management services. The reason that makes a difference, you can see, if you go back to stages 1 and 2 at paragraph 13, is that if the sale of shares was exempt, then prima facie, you end up saying, well, that's directly linked to an exempt supply, no recovery, and if it's outside the scope, you go to stage 2. And so that is the difference. That's the only difference that's ever been suggested as between an exempt supply of a subsidiary and then outside the scope. It happens right there at stage 1. And you can see how the matter is treated. In fact, you have seen how the matter is treated when it's an outside the scope transaction, because that's what was dealt with in Kretz Technik. And I refer to that at paragraph 18. And it's important, I think, to look at exactly what treatment applies there, because when we come to SKF, the court says, in terms, the same treatment must apply as if it was outside the scope. So the treatment we see in Kretz Technik is what we will be told later when we come to SKF to apply to our exempt sale. So if I may just briefly trouble you again to look at Kretz Technik with that point in mind. I know you've seen it several times. I may be unnecessary, but it's page 399, which would be behind tab 27. And it's paragraph 36, please, on page 399, tab 27. But and you have looked at this, but can I just ask you to look at it with the point in mind that it's this same treatment that we're going to have to apply, on my reading of SKF, to an exempt sale of a subsidiary. And specifically, what we can see is if the operation was carried out in order to increase its capital for the benefit of its economic activity in general. So it's not automatic. I've never said it's automatic. You have to satisfy the test that applies in relation to an outside the scope transaction, which is stated there, if the purpose is to raise capital for the benefit of your economic activity in general. So if that test is met, then it must be considered that the cost of the supplies acquired by that company in connection with the operation concerned, form part of its overheads. So if that test is satisfied, you must decide that those costs are part of your overheads and are therefore as such component parts of the price of its products. So the treatment you get as an outside the scope supply is if the purpose was to raise capital for the benefit of your activity in general. Not automatic. If that test is met, then you must treat those costs as being overheads and therefore, as such, component parts of the price of its products. So, as I'll say later, when the Court of Justice tells us to apply the same treatment we would have applied to an outside the scope sale to an exempt sale, it's this treatment here. The only distinction between an outside the scope sale and an exempt sale is that stage 1 issue. There's no issue at stage 2. Stage 2 is not even concerned with what the share sale was. It only arises at stage 1. And it's that issue that the Court of Justice directly raises, directly deals with, and modifies the result in SKF. So if we could go back to SKF and look at it, I apologise that you've looked at it in detail, but there's no escaping the fact that I need to take you through it as well.
Just before we get there.
Yes, of course.
I hadn't appreciated that paragraph 36 of Crest Technical was quite so fundamental to your arguments. This has been very helpful. I read in paragraph 36, regard is had to the fact, first, the share issue is an operation not falling within the scope of the 6th Directive. So you say that's the bit, that is a part of the reasoning that comes, that's a sort of setting the context, and that when we get to SKF, where the share issue is an operation, is an operation which does fall within the scope of the 6th Directive, what you're saying is the rest of paragraph 36 mirrors across. So in other words, that first criterion isn't material to the analysis that follows.
Well, the court says that. So the court says that if this was a case where it did fall outside the scope, then you would apply their Kretz-Technik type test.
Right. Paragraph 36.
Paragraph 36, and then it says to avoid a breach of fiscal neutrality, if it's an exempt one, you must apply the same treatment as you would have done if it had been outside the scope, and therefore that's when you read across back to what would happen then. Well, the answer is in Kretz-Technik. So
in everything after.
Everything after that in 36, yes. So you're applying 36 on the basis that it also applies where it's an exempt. Well, a modification.
Modification, or whatever.
Yes.
But that's the bit that you have to change here. So you're very happy with the second criterion, that the operation was carried out by the Cambridge in order to increase its capital.
Yes.
And that's so that becomes really the only criterion, is that where you've got a share issue, in order to increase the capital, it must be considered that the costs are overheads.
It
really doesn't matter whether you're exempt or outside the scope.
It doesn't matter.
If you've got a share sale which was carried out to increase the capital for your economic activity in general, then you're into this.
If that is the reason for the transaction, which it is here, then you apply what follows, which is that you treat it as overhead. Yes, and therefore as a cost component of the price of its product. On the other hand, if that wasn't the purpose, if you raised money with no particular idea of what to do, or you just sold a subsidiary because you got a particularly good price for it, and then you had a lump of cash and you'll decide later what to do with it, then you wouldn't satisfy this test. So it's not automatic, as perhaps was referred to this morning. There are cases, and they're not before you, but there are cases where the Court of Justice said, no, although you've sold a subsidiary in these circumstances, the intention was to pay off a bank loan, and you were in liquidation, so it actually wasn't to benefit your economic activity at all. So there are cases that deal with that. But in a case where you do satisfy that test as to why you're carrying out the transaction, then you do go on to apply the consequence, which is it's part of your overheads. And that makes sense. I'll come to this later, because otherwise you're denying the trader the opportunity to deduct the costs it's incurred essentially exclusively for the purposes of its taxable economic activity. It needs to raise money. It has a number of different options. Could be a bank loan, full recovery. Could be the sale of a subsidiary that would be an outside the scope, full recovery. And then the problem is, well, what if you sell a subsidiary that happens to be an exempt sale because you provided management services? That's the issue SKF directly addresses and deals with. If we could then turn to SKF, which I think is in the next tab, and if we could look at the facts first of all, because my learned friend made some broad brush comments about, well, possibly this is what the Court of Justice could have had in mind. And I think her examples were Midland Bank type situation where after the event of a failed transaction there's a legal dispute, then maybe possibly that could be something you can attribute to overheads. And then I think her other example was, well, maybe you take on a broad accounting service and within that there's something that in some way relates to the share sale. If you overall characterize the supply and it doesn't actually just relate to that, it relates to everything, then maybe you get past it. That's not what this case is dealing with. If we can look, please, at paragraphs 20 and 21. The share company SKF is the parent of an industrial group which carries on activities in a number of countries. It plays an active role in the management. Sorry, this is page 423, if I may not have mentioned. So it's telling us the facts because, as we see, that the Supreme Court later says in Frank A. Smart, in circumstances analogous to the facts of the case. And these are the facts of the case. So it's a holding company, plays an active role in the management of its subsidiaries, making supplies to them for consideration of services, and it invoices them for VAT. That's 20. 21, SKF intends, this is a prospective case actually, intends to restructure its group, and in that connection to dispose of the business of one of its wholly owned subsidiaries by transferring all the shares, and also to dispose of a minority share in another company, which in the past was wholly owned, and to which SKF supplied as parents services which were subject to VAT. The reason for those disposals is to obtain funds to finance other activities of the group. There's your Kretz Technic prior question. In order to carry out those disposals, SKF proposes, so it hasn't done it yet, but this is what it's proposing to do, to acquire suppliers of services in the area of valuation of shares, assistance with negotiations, and specialized legal advice for the drafting of contracts. Those suppliers will be subject to VAT. Those are the services that this case is concerned with. Nothing of the sort my learned friend was trying to hypothesize. These are directly concerned with negotiation, valuation, drafting of contracts. They are as directly connected to a sale of shares as you could imagine. And the Court of Justice is plainly aware of that because it sets it out in paragraph 21. You can see the query at 22. In order to obtain clarification of tax consequence of those disposals, SKF applied for a preliminary decision on the right to deduct input tax paid on the supplies of services acquired as part of the disposal of the shares in the subsidiary. These are services acquired as part of the disposal. They're directly linked to the disposal in any possible sense. You can see the question itself. You can see the question itself posed at 25 sub 3. Irrespective of the answer to the above two questions, can there be a right to deduct for expenditure directly attributable to the to the disposal transaction in the same way there is for general costs? So that was the question. If they are directly attributable to the disposal transaction, is there any possibility of a right to deduct? And on my learned friend's case, the answer to that should have been a short no. You've told us what the costs are, valuation, negotiation, drafting contracts. You've told us they're directly attributable. And then you've asked us, can we recover any input tax on costs directly attributable to the sale? And my learned friend would need the court to have said, no, absolutely not, see BLP. And it doesn't do that. And we'll see the Supreme Court makes it clear that it doesn't do that. But just to see how the question is posed. We then please go forward to the answer to the third question, which is on paragraph 54, page 429. And again, we can see the framing of the question. By its third question, the referring court asks, in essence, whether there is a right to deduct input tax on services required for a disposal of shares. So the services are required for the disposal of shares. These are not things happening afterwards. These are not accounting services that incidentally might say something about a disposal of shares. These are explicitly services required for a disposal of shares. And you can see that. You can see that in the nature of the services. Valuation, negotiation, drafting contracts. Very clear. And that is the context of the question and the answer. My learner friend then took you through 57, 58, 59. And that is essentially setting up the problem. That is describing the general position, as I accept in my skeleton, in terms of the stage 1, stage 2 analysis. But that is the background. That is the reason why there is a problem. And I'm not going to take you in detail through those because you've read them this morning. In my submission, they are the background to the problem. 64, we turn to the useful answer. And on my learned friend's analysis, he says, well, actually, this is a useless answer because it's very misleading. Certainly when in the hands of myself. And actually, the answer on those facts must always and necessarily be no, you cannot recover VAT because these services are required for the disposal of shares. That's exempt. But the court doesn't do that. It says, well, actually, in order to give you a useful answer on the facts that you've described, here's something you need to know.
But we do, I mean, maybe you don't want to dwell on it, but you have missed out a chunk, 61, 62, 63. The court explains the problem. You've been careful to identify the problem. The problem is the way the referring court has described the costs in two different ways. That's the paragraph 61 problem. And the immediate solution by the CJU seems to be at paragraph 62, saying, so in that case, all we can really do is send it back to the court to have another go. And it's in the light of that that we then get to the useful answer points at 64 through to 68. I mean, that sequence is right, isn't it?
Yeah, I don't disagree with that, but I mean, we've been through what the costs are.
Yeah.
They are clearly required. The question is framed in terms of costs that are required for the disposal of shares. On my learned friend's approach and interpretation, the only result of that can have been to say they are not recoverable, those costs. The referring court describes them as directly attributable to the disposal of shares. Fine, that's correct in terms of they're required for this.
It's also forming part of the general costs associated with the overall economic activities.
Which may well be true, but you get blocked at stage 1. You get blocked at stage 1 on my learned friend's analysis.
Because if they're directly attributable to the disposal of the shares, it's irrelevant that they're part of the general costs.
Well, it should be. It's not. It should be.
No,
it's
no,
not.
no, exactly. But applying that analysis,
Yes.
the second bit.
Yeah, so you can say, well, the costs are fund because they quite clearly are. And if you look at Kretz Technic, they are, because it's outside the scope, it then says, well, look at the purpose. The purpose is to raise funds. They're part of your overheads and they are for your general costs. So you've got Kretz Technic telling you those costs are part of your general costs. But on the HMRC analysis, you never get to benefit from that conclusion conclusion because you get blocked at stage 1 because of the direct link. The direct link to the share sale doesn't mean that in some general sense you can't say, well, these are part of our general cost. It doesn't mean that that's wrong to say. It just means it doesn't help you.
Isn't it? But then you get, so, sorry to pick away at this, but
Okay.
I think we're in the guts of it now, if I may say so. So para 62, so you've got 61, as I read it, the court saying, look, we've got this, the national court saying, first of all, you've got a direct attribution to the shares, and secondly, that this costs form part of the general costs.
Yeah.
So what do they do about it? The paragraph 62, the court says, well, we can't tell from the case file where the direct and immediate link properly lies, and it's back to the national court to tell us, to say whether those costs have a direct and immediate link with the share disposals or with SKF's overall economic activity.
Yeah.
So isn't that the question they're sending back? To say it's the either or point, isn't it?
Yes.
It can't be both for the reasons we've discussed.
It can't be both. It can't
be both.
The direct link can't be both. But you can still describe something that has a direct link with the share sale as never as being part of your general cost. I mean,
on your case, they wouldn't need to do this either, would they? Because they say it doesn't matter. It's obvious that there's a direct and immediate link with the share sale, but this is a fundraising case, so all you need to do is look straight at the link with economic activity is enough.
Well, they would need to do that because this is the first case that does that. My ladies, without this, all we would have is BLP, which the Supreme Court said the ruling there is modified. This is the modification of the ruling. So, my lady, it would have been necessary. You couldn't just stop there because there'd be no other case prior to this telling you to undertake that exercise. This is the case that makes the modification, as the Supreme Court says. So, on my learner friend's analysis, should have stopped there. Don't worry, you've said it's directly attributable to the shares. You said they're required for the share sale. Frankly, it's quite clear from what you've described them. They are required for the share sale. That's the end of the analysis. See BLP and our case law system.
The AG was right.
And the AG was completely right and all that. Just reiterate the chain-breaking effect of an exempt sale. That would have been the answer. Should have been the answer. This is not concerned with a Midland Bank type situation. It's not concerned with broad accounting services that in some way incidentally touch upon. It's not concerned with anything like that. It's very, very specifically valuation, negotiation, drafting.
But this is a case where the National Court, I might use the wrong language, forgive me, has a choice. In other words, it's got to decide, it's either or, which one these costs attach to. And that only matters if you can, that could only matter if the cost did attach to the share sale, the exempt share sale, that was the end of the question. And if they did attach to the general overheads, that was the end of the question. See what I mean? It was an either or. It was an either or, but the logic by which you can positively answer the second part of my lady's or depends upon what comes next. Okay, well, let's keep going anyway. Yeah.
Because, well, I mean, I think the short point is the case could have ended there on my learned friend's analysis, but it doesn't. The court goes on and it gives a useful answer. And then we see, it must be recalled, the court has held on numerous occasions there is a right to deduct on consultancy services used for the purpose of various financial transactions on grounds they are directly attributable to the economic activities. It refers to Midland Bank, Abbey National, etc. Then it says, well, admittedly, in those cases, the output transaction in the shares, which led to the above-mentioned judgments, unlike in the main proceedings, were outside the scope. So it's saying, yes, we have got a history of saying you can recover VAT, input VAT, on fundraising transactions. That's 64. 65, it says, well, admittedly, those cases were all outside the scope. So they were different. Because here we've got an exempt sale. And then it goes on. However, as is clear from the case law cited above, the main factor distinguishing the classification of those transactions from that of the transactions which come within the scope of VAT but are exempt from it is whether the company which is liable to the tax is or is not involved in management. So it's saying, yes, our case law on recovery of input in relation to financial transactions relates to outside the scope sales of subsidiaries. But the difference between an exempt and an outside the scope is actually just whether you happen to manage a subsidiary. Okay. And then it says at 66, if the right to deduct input VAT paid on consultancy services relating to a disposal. So, I mean, my learned friend tries to say there's some big switch in language here, but with respect, that can't be right. At 64, it's talking about consultancy services used for the purposes of various financial transactions. And then it carries that through into 65, and at 66, I mean, the idea that there's been some fundamental change of concepts here is not plausible. I'll come back to that shortly, but just to make that point. If the right to deduct input VAT paid on consultancy costs relating to a disposal, which is exempted because of involvement in the management of the company whose shares was sold, was not allowed. So pausing there, let's try and understand that if we may. Why would those inputs on those consultancy services not be permitted to be recovered? Answer, because they are directly linked to the share sale, and therefore you get stopped at stage 1. So that is the premise of 66. If the right to deduct input VAT was denied because you involved yourself in the management of the services, but in contrast, if the right to deduct input VAT in respect of such costs relating to a disposal which is outside the scope was allowed, on the ground that those constitute general costs, that would amount to treating objectively similar transactions differently. So it's absolutely clear, beyond any peradventure, that the distinction being set up here is between costs that are directly used in a share sale. You can put that in any different way you want. They relate to it, they're connected with it, they're used in it. But that is exactly, this only makes sense on the basis that they are used in the share sale and therefore will be blocked at stage 1 under the normal traditional analysis, if I can call it that. That is part 1 of 66. The contrast is then, well, with exactly the same situation, but the share sale is not exempt, it's outside the scope. And in that situation, you apply Kretz technique, and you apply the test of, well, is it for the purpose of raising funds for your general activity? And you conclude, yes, it is. Therefore, Kretz technique tells us to treat it as general cost. So you will get recovery. That's the difference in treatment. There is, and I'm not aware of it ever being suggested, that if you get past stage 1 in relation to an exempt share sale, there would be some difference of treatment, or could be some difference of treatment at stage 2. I've never heard it suggested in terms of whether you can treat them as general costs. It just doesn't make sense. Why, if at stage 1 you've concluded it's not directly linked to the share sale, do you then at stage 2 have some difference in whether it can be general costs based on whether the share sale was exempt or outside the scope? And this is a point that troubled the Upper Tribunal. You can see it from their judgment. They couldn't understand how any difference of treatment could possibly arise at stage 2. No one's ever suggested it could. So why would there be anything to deal with there? If you get past stage 1, because it's not directly linked to the share sale, stage 2 for both outside the scope and exempt is exactly the same. It's exactly the same.
But isn't the issue for the HMRC's case at stage 1, not stage 2? If you do get past stage 1,
yes.
then there is no difference at stage 2.
Exactly, but that's the point, because my learned friend is saying this was that the way you should interpret SKF is as solving some sort of issue at stage 2 and ensuring fiscal neutrality at stage 2. Yeah. Her case is that it doesn't require fiscal neutrality at stage 1. You have to satisfy that.
There isn't fiscal neutrality at stage 1. She says that you're looking at different things. She says well, there isn't fiscal neutrality and that's okay. It's essentially HMRC. Oh, sorry, there isn't fiscal comparability at stage 1. She says.
Yeah. Obviously, my learned friend is the best person to frame her case, but essentially she says that the Court of Justice and the House of Lords, the Supreme Court, neither of them were concerned with achieving any sort of similarity of treatment at stage 1. It was only if you got past stage 1, then at stage 2, this is where the Court of Justice sweeps in and says, don't worry, you'll be treated the same as stage 2. But as my lady says, nobody was ever suggesting otherwise. There was never any conceptual basis for saying at stage 2, you might be treated differently based on whether at stage 1, the transaction to which your X hypothesis not directly attributable was exempt or outside the scope. No one's ever suggested that. It doesn't make any sense. And in terms of objective similarity, well, the answer is there at the end of 66. That would amount to treating objectively similar transactions differently for tax purposes. So the Court of Justice is telling us, in terms, that a sale of shares of a managed subsidiary is an objectively similar transaction to the sale of shares of a non-managed subsidiary for this purpose. It's saying that.
If it is saying that, it's overruling the LP, isn't it? And it's also, isn't it, creating a derogation to the directive?
In blunt terms, it does depart from the LP. It's not overruling the directive because the case law on what is or is not a direct link or when goods are used for a particular purpose is entirely in the hands of the Court of Justice. It's not saying you can recover these even though they're not used for the purpose of a taxable transaction. It's saying, well, this is how you should approach the question of whether they are used for a taxable transaction in this particular context. It's not overriding the directive. That's not right. It is.
But it is overruling the LP.
It's well, the Supreme Court says it's modifying.
But
yeah.
The LP was the paradigm case of an exempt sale of shares with a taxable long-distance set of activities.
Yeah.
And the LP decided that the exempt sale of shares consumed the inputs in question.
Yes.
End of story. I mean, I know there are other aspects.
Yes.
But that aspect, that basic fundamental aspect of the LP could not stand in light of paragraph 66 on your analysis.
Not if you satisfy the terms of this in the sense that you're raising it for the purpose of a general activity, then yes, that's right. And the Upper Tribunal understood that, the Supreme Court understood that. And the thing about the Court of Justice is it rarely, if ever, in terms says, and now you shouldn't follow our earlier judgment. It just sort of does it by further explanation, which is what this is. And it's left to national courts to work out where the truth now lies. So just lingering on 66 for one final moment. So we've set up the difference in treatment. The difference in treatment arises at stage 1 because that is where, if it's exempt, the input tax will be blocked. That's the not allowed in the third set line. Whereas in the outside the scope, it won't be blocked there. You'll get to the second stage, and it will be allowed. That's in the fifth line. The Court of Justice then tells us in terms those are objectively similar situations, and then it tells us in terms that treating them different would be an infringement of the principle of fiscal neutrality. So what is the problem? It's that difference at stage 1. There's no other problem. It then goes on to 67 to say, well, the principle of fiscal neutrality is a fundamental principle, and it precludes treating similar suppliers of services which are in competition with each other differently. And further precludes economic operators, this is just above H, who carry out the same activities from being treated differently as far as the levying of VAT is concerned. So it just gives you a flavor of the principle of fiscal neutrality. And then goes on to apply it. 68. It follows that if the consultancy services relating to disposals of shareholdings are considered to form part of the taxable person's general costs, in cases where the disposal itself is outside the scope of VAT, the same tax treatment must be allowed if the disposal is classified as an exempted transaction. So that is raising the problem at 66 and then saying that if those consultancy services would have been treated as general costs, if this had been outside the scope, then you get the same treatment, i.e. treat them as general costs, if it's an exempt sale. So it's not automatic. You still have to consider what would have been the case if this had been outside the scope. That's the Kretz-Technik question. But if you pass that test, if it is for the purpose of raising capital for the purpose of your general activity, then we are told in terms that the same tax treatment must be allowed. What is that tax treatment? It's treating them as general costs. I laboured Kretz-Technik for exactly this point, because that is the treatment. Because what Kretz-Technik then tells you, if they are part of your general cost, then they are necessarily, therefore, cost components of your products as a whole. So you get the cost component answer from them being part of your general cost. That's what Kretz-Technik told us. My learned friend tries to say, well, this is all just limited to costs that are relating to the share sale. And she, as you've seen, she focuses on the words relating to in 66 and 68. With respect, that doesn't make sense. Costs that are directly attributable to a share sale plainly relate to that share sale. I mean, you might, my little friend might be able to argue that relating to encompasses a broader category of costs, but it must at least include those costs that are directly attributable to the share sale. How can one say they're not related to the share sale? They plainly are related to the share sale. So that's with respect, it doesn't get my learned friend anywhere, that sort of linguistic nicety. And nor does it fit with what the Court of Justice is saying, because you can go back to 64, which introduces the problem. It's the right to deduct VAT paid on consultancy services used for the purposes of financial transactions on a particular ground. There's no change of meaning. There's no narrowing or broadening or carving out of a category when we get to 66 and consultancy costs relating to a disposal. And nor does that paragraph make any sense if my learned friend's right. Because I've made this point before. The reason why costs relating to a disposal of shares would not be allowed if the sale is exempt is precisely because they are directly attributable to the sale of shares, therefore you get blocked at stage 1. That is the reason. There is no other reason. So the only way you can make sense of the first part of 66 is if those costs, consultancy costs are related to the disposal of shares, are ones that will be blocked at stage 1 because they're directly attributable to the sale of shares. That's the only way it makes sense. And if you just read paragraph 68 and apply it to our facts, you cannot come to any other conclusion than it applies. It says if the consultancy costs relating to the disposal of shareholdings. So our costs do relate to the disposal of shareholdings. In fact, my learned friend's case is, well, they definitely do relate to the sale of shareholdings because they're actually used in it. So there's a very strong connection. There's a very strong relationship. So if the consultancy costs relating to the disposal of shares are considered to form part of the taxable person's general costs where the disposal is outside the scope of VAT. So then we ask the question, if instead of having an exempt share sale here, we had to do an outside the scope, would we treat these costs as general costs? Answer, yes, see Kretz-Technik. So it's not automatic, you still have to apply the Kretz-Technik criteria. So do we satisfy the first part of 68? Yes, we do. Has any reason been suggested why we don't? No, it hasn't. What happens if we do satisfy it? The same tax treatment must be allowed if the disposal is classified as an exempted transaction. What is the tax treatment? It's treating it as general costs. It's treating it as being a cost component of your products in general. That's the Kretz-Technik answer. 36 of Kretz-Technik. With respect to my learned friend, there is no other interpretation of these paragraphs that makes any sense. My learned friend tries to interpret it as saying, well, it's if you get to stage 2, then you get the same treatment. But there was never any suggestion, there never has been any suggestion you get a different treatment at stage 2. In fact, BLP itself acknowledges that at stage 2, you can recover as overheads if you get there. So it wasn't as if BLP ruled out the possibility of costs being general costs if you got to stage 2. It just says, well, you never get there. Indeed, you can go back to BLP. If we could go back to page 339, it's tab 24. We'll be coming back to SKF in a moment, but just to make good this point. Tab 24, page 339. Because listening to my little friend's submissions this morning, one might have thought that the possibility of costs being general costs or overheads was something that came after BLP, and she says, well, that's in some way the modification. But at 25, you can quite clearly see that's not right. It is true that an undertaking whose activity is subject to VAT is entitled to deduct tax on the services supplied by accountants or legal advisors for those taxable transactions, and that if BLP had decided to take out a bank loan for the purpose of meeting the same requirements, it would have been entitled to deduct the VAT on the accountant's services for that purpose. However, that is a consequence of the fact that those services whose costs form part of the undertaking's overheads, and hence of the cost components of the products, are used by the taxable person for taxable transactions. So the idea that you can have overheads and they form part of your cost components as a whole has always been there. It's not new. It didn't happen after BLP. And then you can see at 26, the fiscal neutrality problem. And the court just takes a different view. As my lady says, it just takes a different view in SKF. In BLP, the court says, yes, there's a breach of, well, yes, there's a difference in treatment, but that's something that you'll just have to live with.
But it doesn't say that. It says they're different. There is no fiscal comparability. They're different transactions. You choose what you want to do.
Well, yes. It says yes.
It's not saying they're the same, but you just lump it. It really isn't saying that.
Well, it's saying you live with the consequences of what you've chosen to do. Whereas in SKF, they take the opposite view on that same question. That's what happens. Because there is no other fiscal neutrality question. My learned friend certainly hasn't identified one. And so where you do have a later court decision of the Court of Justice saying, actually, there is a problem with fiscal neutrality here, and here's how you solve it, then you follow the later one. And that's what the Supreme Court tells us in Franquet-Smont. Apologies for that diversion. If we could go back to SKF, so that's tab 28. We were at paragraph 69, I think, or about to go to paragraph 69. So I've made my submission that in terms, we satisfy every element of 68. There's no wiggle room there, we just satisfy it. And then at 69, the court says that interpretation, so it's an interpretation, it's not overriding the directive, it's an interpretation, is borne out by the purpose. And we know very well that purpose is very strong in VAT law and EU law generally. which is in particular to secure the equal treatment of taxable persons. So we've been told that an exempt sale is the same transaction, or a very similar transaction to a outside the scope, and then we're told that it's important that people carrying out those transactions should be treated equally. At the top of page 450 in the report, that principle would be disregarded if the costs incurred by a parent company managing a group of companies in connection with a sale of shares, which is part of its economic activity. So now we're referred to costs incurred in connection with the sale of shares, but all the time it's referring to the same thing, and clearly the court has in mind the particular costs in that case. So costs incurred in connection with the sale of shares, which is part of its economic activity, were to be taxable, while a holding company which carries out the same transaction outside the scope of VAT would be entitled to deduct the same costs by reason of the fact that those costs form part of general costs. So it's telling you again, look, if a company that made an outside the scope disposal of a subsidiary could recover, but a company that made an exempt sale could not recover in respect to the same costs, then that principle would be disregarded. So it's that problem it's fixing. And at 70, any other interpretation would burden the trader with the cost of VAT in the course of his economic activity without giving him the possibility of deducting it. So it's clearly concerned to ensure that these traders carrying out these fundraising transactions can recover the VAT, if any, associated with that fundraising, irrespective of whether the underlying fundraising transaction happens to be outside the scope, happens to be exempt, or happens to be an issue of shares. Then 71 must be read in light of what we just read. In the case, in the main proceedings, while it is admittedly true, as is correctly argued, that a disposal of shares which is exempt from VAT does not give rise to a right to deduct, the fact remains that interpretation holds true only if a direct and immediate link is established between the input services and the exempted disposal. If, on the other hand, there is no such link, and the costs, the input transactions is incorporated into the price of the products, the right to deduct VAT should be allowed. Go back to paragraph 68. What are we just being told to do? We have just been told, in relation to an exempt sale of shares, to give the same treatment as if it had been an outside the scope sale.
That's what they meant. They could have been a bit clearer.
Well, they are, my lady. If we read the beginning of 72, it must lastly be stated that there is a right to deduct input VAT in respect of services carried out in connection with the financial transactions if the capital acquired by means of those transactions is used in connection with economic activities. That's unqualified. It's not there might be a right, subject to various tests that my learned friend would have you apply. It says...
That's stating the ordinary things. If you use your input for making taxable outputs, you can recover it. That's just the vanilla stuff, isn't it? It's not saying anything new there.
Well, it's saying that there is an unqualified right to recover input tax in respect...
We know there is. If the input tax is used in connection... Well, I read that to mean taxable services.
Well, the services have to be taxable, otherwise there's no VAT on them. That's the input.
Yeah, I agree.
So, well, if we just...
I actually want to just pause and go back to paragraph 71.
Okay, of course.
Because 71 appears to be back in the either-or territory. And if in fact what they're saying is, look, when you come to looking at these sorts of costs, even though you have got an exempt disposal of shares, you don't need to worry about whether there's a direct and immediate link with the exempt shares, because all you need to look at is the Kretz-Technik analysis, which we've tried to describe to you in paragraph 66 and 68 above. And you just ask yourself if the costs are linked with the exempt, with the general
Well, it's...
overhead, the general outputs.
At 71, it's squaring what it's just said with the objection by the UK and other governments. Because their objection is, well, hang on, we always thought if it's an exempt share sale and you used it for the purpose of the exempt share sale, then you don't get recovery. And the court says, well,
It says, yeah, you're right.
you're right insofar as that goes, subject to the motive.
You say you're right.
If-
That is right.
If,
You don't get your tax back.
but then,
If, on the other hand, there is no such link.
and that's the 68 modification. What else can 68 mean? What else? Because if 68 doesn't mean that, it does nothing.
But it's just, we're stretching these words more than just a tiny bit, aren't we? If, on the other hand, there is no such link, is not the same thing as saying, in these sorts of cases, there is no such link. We've told you that. Go back to 66 and 68.
Well, my submission is it does say that right afterwards in 72. But if you go back to 68, what does it say? What does it say? It says the same tax treatment must be allowed. So as if it was outside the scope. What would the tax treatment be if it was outside the scope? You would say no link to the transaction, the shares. You would instead say linked only to and forming part of the costs of the general activity. That is what you would say. That's why I started with Kretz Technic, paragraph 36, because that says in terms that in those outside the scope situations, it is part of the general cost. It is part of the cost of the products in general. And we are told in terms at 68 that that tax treatment, that same tax treatment must be carried across. And if we've carried that across, as we are told to do, the answer at 71 will be, well, because we've applied the modification at 68, actually they're not linked with the share sale anymore. Actually, they are linked with the general cost.
Why then did they send it back to the Swedish court? Why didn't they just say, on the facts which the referring court has explained to us, these costs, there is no link. There's no direct and immediate.
Because it's never for the Court of Justice to actually apply the law to the facts. It only gets referred questions of law. So you see this in numerous cases where the Court of Justice has basically told you the answer, but it will not actually, in terms, tell you the answer, because that would be to step into the shoes of the national court. You can see, it tells you that that's at 60, 61, 62, 63. It says it's not for us. See, at 63, in proceedings brought under 234, since the court has no jurisdiction to assess or characterize the factual circumstances which gave rise to the questions referred. So it has no jurisdiction.
But in BLP they decided, in Abbey National they decided, in all those other cases we looked at, they gave the answer.
Well,
Here they had a problem. They didn't understand the fact-finding of the Swedish court.
well, but the question was very specifically, these services are required for the sale of shares. And then it told you exactly what the services are. I think they were negotiation, valuation, drafting of contracts. And the court says that for services that are in connection with the sale of shares, at 68, you must give the same treatment. And so the question then becomes, so it's not automatic, as I said, the question still becomes, well, is this transaction for the purpose of raising funds for the general activity? So there's still a factual question you need to answer. And then there is also then the question of, well, what is the overall activity? Is it taxable or partly exempt or exempt? So it's not automatic. And the court has said, look, we can't just tell you the answer.
But it always goes back to the referring court anyway. It's not that the CJE needs to send it back. Usually they just answer the question. So why didn't they answer the question saying something like, in cases which are to do with, in cases where shares are sold in the context of fundraising for wider purposes of the business, fiscal neutrality requires that input tax associated with that sale is recoverable as attributable to the business, and no question arises about whether it's attributable to the exempt supply.
It does at 72, my lady. That's exactly what it says. You can consider what's the alternative. If I'm wrong about that, if instead this has done nothing to change the law in relation to stage one, does it make sense? How does it make sense? My learned friend strained to try and find a way it made sense, but with respect, I don't think she succeeded. In my submission, she didn't. Because if one accepts the very problem identified at 64 to 66 is this difference of treatment that I've been talking about, then the solution at 68 must be dealing with that problem in some way.
It follows from the way you're inviting us to read it that at stage 1, you must conclude that there's no direct and immediate link, because if there was a direct and immediate link with the share sale, the exempt transaction, you never get to the stage 2 question. And at 71, where they're dealing with the arguments by the various national governments, they say it is true that a disposal which is exempt does not give rise to a right to deduct. And they say, well, that's only true if there's a direct and immediate link.
Yes.
So that suggests there's still a question to answer. Is there a direct and immediate link? But on the way you ask us to interpret it, you don't ever answer that. You don't really ask that question.
You do, because the Kretz-Technik treatment will only apply if, had this been outside the scope, you would have achieved general costs. So you still have to ask, is this transaction for the purpose of raising capital for your benefit, your general transaction? If the answer to that is yes, you're within 68, you apply the Kretz-Technik treatment, and therefore you conclude, well, the link is not with the specific transaction, it's with the general activities. And that's how the end of 71 is then satisfied. Because that's the only way this makes sense. Otherwise you will always be blocked at stage 1.
Yes.
And what is the point of 64 through to 68 and 69, 70? That's the puzzle. I mean, well, on my learned friend's case, that is the puzzle, because with respect, she hasn't identified anything that 68 is dealing with. Her suggestion was it's all about stage 2, but I submitted and established very early on, there is never any difference in treatment at stage 2. If they're general costs, it's the same test for general costs, whatever the facts were at stage 1. So my learner friend hasn't identified any problem. And that's why I labeled paragraph 66, because that is the problem. And that problem only arises because of the stage 1 difference. It is a stage 1 problem at 66.
So you say it all hinges on 68, which says it follows that if the consultancy costs relating to disposals are considered to form part of the taxable person's general costs in cases where the disposal is outside scope, the same tax treatment must be allowed if the disposal is classified as an exempted transaction.
Yes, that's the modification.
So that's the key. That's the key
modification.
to the reasoning.
It's not the only key, because the key is to read that with the problem.
Yes.
So one has to understand the problem to understand the answer. And the problem has to be something that actually makes sense and exists as a problem. And the Court of Justice has made it very clear what the problem is. It's the same problem that in BLP the Court said wasn't a problem. It now says is a problem. There's no other problem. If there was an alternative, I might have to deal with something, but there's no other problem.
So that seems to be saying you're not bothered with the stage 1 question where the transaction is exempt. In which case, I just don't understand what they say later in what they say in 65.
It's 65, my lady.
Sorry. No.
71.
71, yeah.
Well, my lady, it's an example. So, as I said, it's not automatic. If you had a sale of shares in a subsidiary which you did manage, and the reason for sale was simply that you got an attractive price, and you hadn't got any particular designs on what you were going to do with the money, then you could not say in those circumstances the purpose of this transaction is to raise capital for the benefit of our wider economic activity. In that situation, you would still be blocked at stage 1.
Right.
Because you would not satisfy the Kretz-Technik question. I'm calling it that, it's not just Kretz-Technik, but that question as to the purpose of the fundraising. And so you would be blocked at stage 1 because there would be a direct link and there would be no modification at 68 because the problem here is not whether it's outside the scope or exempt. The problem here is you're just not raising money for the purpose of a taxable activity.
Right.
So in that situation, then, you would say, well, the only direct immediate link is with the share sale. That's exempt, no recovery. But in a different situation, which is our situation, where the purpose of the share sale is to raise money for the purpose of your taxable wider activity, you apply 68 and say, well, we must give you the same tax treatment as if this was outside the scope, which would be to treat it as general costs. And the general costs are ones that incorporate in the price of your products as a whole. And so the tax treatment of that is you get recovery. And so 71 makes sense when read with the modification at 68, which may or may not apply depending on your facts.
Right.
And I do go back to 72, the beginning of 72, which in plain terms, I mean, there's no word of the first sentence of 72 that we do not satisfy. It must lastly be stated that there is a right to deduct input VAT, that's what we're asking for, in respect of services carried out in connection with a financial transaction, that's our sale of shares, if the capital acquired by means of those transactions is used in connection with the economic activities of the person is tick. We tick every stage of that. There's no qualification there. There's no qualification to say, well, but that's only true if the financial transaction is outside the scope or not exempt. That's what my learned friend would require it to say. It doesn't say that. And my lady was asking, well, why couldn't the court give us a simple answer to not a simple question, but a simple answer to the question? Well, it's right there at 72.
But it goes on, just to help me. I mean, please don't think that I know the answer. Any of us know the answer to any of this stuff. It's not straightforward. Para 72 does have that. I can see why you attach some significance to the first sentence. It's obviously helpful to your case. But the court goes on to a furthermore, which I understand to be a sort of, we're now going to explain what we mean by that. And it then talks about costs associated with input services have a direct immediate link to the taxable person's economic activity. So there we are again, it's saying to the end outputs of the company. In circumstances where they are solely attributable to downstream economic activities and consequently are among only the cost components of transactions within the scope of those activities, citing securenta. So no reference back to Kretz-Technik, no assumptions here can be made or anything like that. It seems to be back to this, our old friend, the direct immediate link test. It's a test of fact, are these inputs directly linked to the longer term outputs of the company?
With respect, my lady, I would say that that's not right. Securenta was the case that decides where you have two activities, one of which is outside the scope and one of which is an economic activity. In the same way as you would do a partial exemption if you had exempt activities and taxable activities, you apply a similar principle to a combination of outside the scope activities and economic activities. So it's dealing with the securenta question. You'll see that in the Supreme Court in Frank A. Smart. But that securenta apportionment is to deal with situations, as I said, where you have an overall activity, some bits of which amount to an economic activity, some which don't.
Okay. But what it doesn't do is it doesn't say Kretz-Technik applies.
Well, that's what it says at 68. And the 72 is exactly what you would expect if I'm right. The same tax treatment, well, you have to ask what the tax treatment would be.
It seems like I understand your argument, but it feels like a light patchwork where, in fact, the court, if you're right, is doing something quite significant, and you would expect it to be really clear about what it's saying, because this is a change to the way things have gone before, and you'd expect it to be clear as a pikestaff about this is the treatment that applies in these circumstances, and only in these circumstances, because everything else we're looking at stage 1, stage 2, it's the normal stuff. We're having to try quite hard, aren't we, to pull in the...
In my submission, we're not, my lady. The only reason we're trying so hard is the skill of my learned friend in trying to make something that's not confusing look very confusing. And that is a skill. But with respect, when you read 66, when you understand the actual problem here, it's not difficult because the only problem arises at stage 1. So there's two possibilities here. Either something is changing at stage 1, or it's not. Because we've identified a problem at stage 1, that's 66. There's no argument, there can be no serious argument about that. And so there's only two possibilities from that point. Either the court says that's a difference in treatment and it's just where the law leads. Or the court's done something and says, well, actually, no, that's not where it ends. Here's a modification. And the only way of reading this is that there's a modification. And then if one wants a sentence that encapsulates what the modification is, it's at 72. And so in my submission, as I said, it's only due to the skill of my learned friend that this is confusing. I'd never found this confusing before I heard my learned friend speaking. That's as I said, it's a compliment, nothing else. But when you understand the problem at 66 and you decide at 68 something's being done about it, the only thing that can be being done about it is what I'm submitting, nothing else.
If you look at 73, which gives the answer,
yes,
it seems very odd. If you're right, you would have expected the answer to be that there's a right to deduct input VAT paid on services supplied for the purposes of disposal of shares if the circumstances are such that the only difference between the only reason the shares are exempt is because of the management services, and had they been no management services, it would have been a case where the services were linked with the overheads generally. That's not the answer they give. The answer they give is it's for the referring court to determine whether the costs incurred are likely to be incorporated in the price of a share sold. Well, what's that got to do with the price of bread? I mean, on your case, that's got nothing to do with it.
well, it has to do with it in the sense that the effect of the modification at 68 is that you will treat them as incorporated in the price of the products in general, rather than the price of the shares. That's the modification that's made. So really, it's saying that the modification must be applied, and the modification only applies if it's for the purposes of raising capital for the benefit of the wider economic activity. So it couldn't just say, treat them, say, irrespective of whether it's exempt or outside the scope. That's not what it's saying. And what it's doing there is it's reconciling what it is saying with the test, and then you have to go back to 68 and 72 to see, well, what happens in a particular case where it is for the purpose of raising capital. So, my lord, does that spell things out as clearly as we would all like? No. But is it clear, based on what it said before, that that's what it means? Yes, because what else could it mean? I mean, on my learned friend's case, consider the opposite, because my learned friend's saying, well, on my test, you'll always satisfy it, so why didn't it just say that? I've said that's not right. But on my learned friend's test, you will never satisfy it, because we are concerned here with services used for the purpose of the share sale. That's the context of the question, that's the context of the answer. And if it was as simple as saying, well, just apply the normal test and to see where that leads, why have we got 64 onwards? And at 73, it clearly anticipates that there may be costs. So if we read 73, my lord, follows from the foregoing, the answer to the third question is that there is a right to deduct VAT on services supplied for the purpose of the disposal of shares. So that's the services we're considering. So even though they're supplied for the purpose of the disposal of shares, the court is expressly contemplating in the next part of the sentence that nevertheless there may be a direct and immediate link with the economic activity as a whole. Which directly contradicts my learned friend's case, because her case is, well, if it's supplied for the purpose of the disposal of shares, it can never, ever be and have a direct and immediate link with the overall economic activity. In terms of how you decide whether it has that link with the overall activity, which must be possible, otherwise it's a pointless answer, well then it gives you the answer, the reasoning in the last sentence, which in my submission takes you back to 68, takes you back to Kretz technique as to how you find out whether something's incorporated in the price. But it is clear that the first sentence of 73 does not make sense in my learned friend's case, because necessarily these are services supplied for the purposes of a disposal. So again, my learned friend talks about relating to, in connection with. Here we're talking about services supplied for the purposes of a disposal of shares. Her case is that, well, that should always lead to the answer that they're not part of your general costs. But here the Court of Justice is saying, well, actually, if there is a direct link, then you can recover. And then it gives you the wording in relation to where it's incorporated in the costs, but you've got to apply that with the modification. And my lord, you see the same thing in the dispositif at 80 sub 3.
Well, they tend to repeat it word
yes,
for word.
it's repeated.
I still have great difficulty with it. If you were right,
Yeah.
I understand entirely what you say about the first sentence of 73, but I would have expected the second sentence of 73 to say it is for the referring court to take account of all the circumstances surrounding the transactions at issue in the main proceedings and to determine whether you fit within 66 to 68, whether it is a case where you're simply raising money for your general activities. Not refer to wherever costs incurred, where are they incorporated? Because how are you supposed to determine that? They give no assistance at all of how you decide.
Well, it's because they've already told you that you need to apply the same tax treatment. It's not always going to be the case.
Yes, I see.
I mean, my lord, could between us we write a much better and clearer judgment if I'm right? Of course we could.
Well, once we know what the problem is.
Is it in the nature of the Court of Justice to do that? Often or not, which is why this court is troubled so often. But that's why we have to undertake the painstaking process of reading the reasoning, understanding the reasoning, and then getting to the answer, and then referring back to the reasoning to try and understand the answer.
Okay.
Fortunately, you've had the Supreme Court look at this, and that's where I'm going to go next. I know the time. I don't know whether the court wants me to start now or to...
Well, why don't we make a start? Presumably you're not under any time pressure.
I don't. Frankly, my case depends upon a close analysis of SKF and Frank A. Smart. So I've done one. The other part is to come, and then I've got my group arguments. So.
We'll make a start, but don't feel obliged to go past 4:15.
I sure, my lord. So Frank A. Smart is in tab 16. I'm afraid I don't know which bundle that is.
A1.
Thank you. If we could look briefly at the facts, just so there's a context, that's paragraph 7 on page 172 of the bundle. And perhaps I could just ask you to read that paragraph, which is fairly dense with facts.
What's astonishing is paragraph 5, the relationship between the main, as it were, agricultural, the amount of money coming in from the main agricultural business and the amount of money coming in from effectively the subsidy payments.
Yes, well, Lord Hodge was clearly impressed with this as a business model.
Yes.
which is you thought of it.
Yes.
I show you the facts only because in this context, the Supreme Court does go on to say, well, you clearly satisfy you do satisfy for the purpose of your wider economic activities, even though you're not actually undertaking any of them yet. It's actually something you're thinking about doing, and even though you can see in the by G, it actually used the money in the interim to pay off its overdraft. Now, my learned friend this morning seemed to be taking a point on, well, you did various things with the money, not just use it to build the hotel. But with respect, that was a point that was raised and then expressly dropped in the FTT, that if we got to stage 2, then we wouldn't be entitled to recovery. So with respect, I would object to her taking any point on that, as I understand it, and as the FTT found, if these are, if we satisfy the purpose test, well, we do satisfy the purpose test, so if we can get to stage 2, then recovery is permitted. I don't know whether that was my learned friend's intention, but I just deal with it in case it was. 21 and 22 set out the nature of the issue. And my learned friend now accepts that it was a stage 1 issue, which is in contrast with her skeleton argument, which I understood as vigorously objecting to this being a stage 1 type issue. And you can see that essentially what Mr. Beale, QC for HMRC, was arguing was that, well, and it's really 22, he's relying on BLP. He says, well, if these transactions had been exempt, you'd have got no recovery. And then he says, secondly, there's no reason in fact or law for reaching a different conclusion just because they're outside the scope. So it was an attempt to extend BLP from exempt fundraising transactions to outside the scope fundraising transactions. That was the argument, which is a stage 1 issue. Very clearly a stage 1 issue. It's saying, if this was exempt, you'd be blocked at stage 1. It's outside the scope, you should be blocked at stage 1. That was HMRC's argument. If we could go then forward to, so at 27, my learned friend's already shown you this, I'll skip over it, but you can see that they raised the issue of BLP. They explain what was decided there, and at 28, just the first sentence, it is clear that this ruling, in terms relates only to the use of service for exempt transactions. What is that ruling? Well, it's the quote in the preceding wording. So, and this is important because we'll see later that the Supreme Court, Lord Hodge, expressly says the ruling is modified. It doesn't say a part of its reasoning was modified, it says the ruling. Here, Lord Hodge is telling us what the ruling is. And so you can see at the end of 27 into the quote, that thus it held, Article 2 of the First Directive, etc., are to be interpreted as meaning that, except in the case expressly provided for by those directives, where a taxable person supplies services to another taxable person who uses them for exempt transactions, the latter person is not entitled to deduct the input of VAT, even if the ultimate purpose is the carrying out of a taxable transaction. That's the ruling. That's the dispositif. That's what's modified. So I emphasize 28 because it tells us what the ruling is. You can see at the end of by D in paragraph 28, when addressing the subsequent case law of the CJU, I will have to consider how, when a taxable person legitimately claims that costs of services are part of its overheads, the tax authorities are to ascertain that those costs are eventually cost components of its products or activities in taxable transactions. 29 deals with Midland Bank, which my learned friends already referred to. 30 is Abbey National. If we look at 31, this is a description of the chain breaking effect. And this is the usual unmodified approach. And can I just ask you to read, therefore, or reread 31, just to remind yourself, because it's this that's then picked up in a moment. That is the difference in treatment that we've looked at 66. That is the chain breaking effect. And you can see the Advocate General describing it in Abbey National by reference to BLP. At 33, the Supreme Court says, well, the court didn't expressly adopt the distinction, but it's implicit that the CJU's reasoning is only consistent with that approach.
This is all Abbey Nationals.
This is Abbey National. So that was an outside the scope. That was a transfer of the going concern. And then we come to Kretz Technic. And my learned friend's shown you this, so I'll deal with it briefly. At 37, you can see that the Supreme Court tells us what the tax treatment is where it's outside the scope. In terms, you disregard the initial transaction if you have that outside the scope transaction. So it's a disregard. And you can see that at 38, the CJU disregarding the share issue. We then get to if I can just show you 40, the quote, this is secure enter, which is the point my lady asked, well, my answer to my lady's question. You can see the decision there quoted, where a taxpayer simultaneously carries out economic activities, taxed or exempt, and non-economic activities outside the scope. Deduction of VAT relating to expenditure connected with the issue of shares and atypical silent partnerships is allowed only to the extent that expenditure is attributable to taxpayers' economic activity. So you can perfectly well have a company that does two principal activities, one of which, because it doesn't satisfy the test of being an economic activity, it's not an economic activity, and the other one which is. And that might be to do with, well, you might have sort of school or something where there's not actually consideration for its supply, so that doesn't amount to an economic activity. But it also makes supplies that are taxable supplies. So that's the sort of situation Securenta deals with. It deals with where you've got both of them simultaneously being carried on. And so even if you get to the downstream, if that's what you find downstream, then it's not partial exemption, but it's the Securenta apportionment. That's what that deals with. I mean, HMRC, that's well established. There can be no disagreement about that. And then we get to 41.
And you're going to go on to SKF.
And yes, and I know at the time, my lord, it's the good bit, but
well, shall we leave it for tomorrow morning?
Yes, my lord. Yes, my lord.
We can anticipate it with eager enthusiasm.
We've stopped on a cliffhanger.
Well, I hate to do that, but the time is what the time
Quite an
is.
important point. So
Yes, with fresh heads. Yes, my lord.
Yes, 10:30 tomorrow.
Thank you very much.
all right.